Over many decades, federal attempts to be able to manipulate federal permit, lease, and land management processes to circumvent long-established state water law and hijack privately held water rights have sounded the alarm for all non-federal water users that rely on these water rights for their livelihood. The federal government's overreach and infringement on private property rights that led to the introduction of the original version of this bill in the 113th Congress involved a U.S. Forest Service attempt to require the transfer of privately held water rights to the federal government as a permit condition on National Forest System lands. There was no compensation for the transfer of these privately held rights, despite the fact that many stakeholders have invested their own capital, many times to the tunes of millions of dollars. This Forest Service permit condition had already hurt a number of stakeholders in my home state of Colorado, including Powderhorn Ski Area and Grand Junction and Breckenridge Ski Resort. Same nefarious tactics have been used in Utah, Nevada, and other western states, where agencies have required the surrender of possession of water rights in exchange for approving the conditional use of grazing allotments. This federal water grab has broad implications that have begun to extend beyond recreation and farming and the ranching community as well, and are now threatening municipalities and other businesses. In 2014, the Forest Service proposed a groundwater directive that would have expanded the agency's reach over groundwater and established new bureaucratic hurdles to interfere with private water users' ability to be able to access their water. Make no mistake, the goal of the directive was to further federalize water resources, erode state authority, and pave the way for unilateral mandates on state water resources while overriding decades of long-standing law and policy that states and states alone hold jurisdiction over their groundwater. Though the Forest Service ultimately withdrew the controversial groundwater directive, there are no guarantees that the directive or some similar will not be back in the future. The Water Rights Protection Act offers a sensible approach to preserve water rights and the ability to be able to develop water requisite to the living arid West without interfering with water allocations for non-federal parties or allocations that protect the environment cherished by all Westerners. As could be expected of West-wide legislation that seeks to protect all water users from relentless efforts of the federal government to extort non-federal water rights, this bill is a work in progress. I look forward to continuing to work with my colleagues from other Western states to ensure that no state-recognized water right goes unprotected from the class of actions that this bill prohibits.